afternoon, all, and welcome to Terra Firma's webinar on Planning Law 2021. This is the last talk in our spring series, and we've done a number. The previous one being Property by Dennis Garrity and Ewan Brand spoke. As with all our talks in this series, the recordings will be on the YouTube channel, that's Terra Firma's YouTube channel, after the event, and slides will be sent to all participants. We are going to have a new series beginning in the autumn, and if you've got any suggestions for topics, do send those to Emma Potter, whose details will appear on the last slide, if I remember to put it up. And I'm sure someone will remind me if I don't. There is a question and answer function, and we aim to finish by about 3 with about 5 minutes, 10 minutes for questions from anyone. So if you think of a question during the course of it, put it up, and then we'll try and deal with such questions as we have time for at the end. And I think that is everything by way of introduction. So our first speaker today is Alistair Burnett, Queen's Counsel, who's going to talk on recent Court of Session planning cases. Alistair, I doubt needs any introduction to any of you, and he has got some familiarity, I think, with most of the cases he's talking about due to personal involvement. But anyway, we'll hear more about that from Alistair. And I'm the man in charge of making sure the slides change, so if he looks grumpy because I haven't changed the slide, that's my fault. You may need to unmute, Alistair.
Thank you, James. I realised you had muted me after our preliminary session. So good afternoon, ladies and gentlemen, and welcome to another seminar in these strange times. And it is strange that hopefully you can see and hear me, but I cannot see or hear any of you at the moment. So until I get a message from James or Emma that there is no longer anyone listening, I'll assume that I'm to carry on with my presentation. It has been a strange year for all sorts of reasons, obviously, but in terms of planning law, it's perhaps a very meager year in terms of cases that the Court of Session has considered this year. And in fact, I'm really only going to be talking about 3 inner house decisions, all in relation to housing development. I'm aware that there were a number of other cases that were raised in the Court of Session, and for one reason or another, a number of them did not progress, but there are certainly another number of cases in the pipeline that others may give indications about later on in this afternoon's seminar. I just reiterate what James said, that the slides will be emailed to all participants after the seminar, and therefore hopefully there's no need to write down too much in relation to my part of the presentation, given that I've tried to quote at some length from the cases, or at least the summaries of them, and we'll be speaking to those, but they should be able to see the pertinent parts from the slides themselves. And with that, I'd ask my glamorous assistant, Mr. Finlay, to change to the next slide. And the first case I'm going to talk about is MacTaggart and Mickel against Inverclyde Council. And I do take responsibility for most of the pictures that have been put into the slides for this presentation. And I'm partly taking a leaf out of the Lord President's book. He is continuing to be keen to not only write judgments on planning, but also in his judgments to include tables and diagrams, which are often extremely helpful. And this particular judgment, he's put in a table or glossary of terms, which is of some use. And in the next case I'm going to talk about, he's put in a diagram to explain the case. But if we go on to the next slide, we can see there were a number of issues that arose in this case. And in a lot of ways, it was a follow-up to the Gladman cases that have been considered by the court over the last couple of years, and the vexed issue of how to calculate the housing land supply, and in particular, how to calculate whether or not there is a shortage in the 5-year supply of effective housing, and therefore to decide whether the local development plan or the development plan was up to date, and whether the presumption in favor of sustainable development in SPP came into play, and how those matters interacted. This, unlike Gladman, was a case of the appellants seeking to challenge not an individual planning permission, but the adoption of the Inverclyde local development plan as a whole. And at the outset, the court noted there were essentially 5, although split down here into 6 issues, which the court was going to consider. First of all, whether the reporter used the appropriate methodology when determining whether there was a 5-year effective housing land supply. Secondly, whether there was proper account taken of the generosity allowance within SPP, and that being the difference between the housing land supply target and the housing land supply requirement. Thirdly, whether the LDP made sufficient provision for private tenure housing, and whether the reporter was correct to look at only the question of all tenure housing as opposed to checking whether the local development plan properly split it down by housing market area, housing market sub area, and as between private and social tenure, to check whether all the figures that were given in the strategic development plan had been properly incorporated into the local development plan. And that essentially also had relevance to the 4th point, whether the LDP identified sufficient housing land supply in the different market areas. And then there was 5thly, a slightly separate point, which really comes down to whether the reporter had taken into account a material consideration, whether he'd properly looked at the most up-to-date figures, which were given in the 2018 housing land audit, which had come after the strategic development plan had been adopted. And then the final issue is really seeing whether, as a result of those or other errors, the LDP failed to comply with SPP and with the strategic development plan, which obviously it is required to do, or at least to be consistent with the strategic development plan. So then if we go on to the next slide, James. I should say before reading out this particular slide that the case as a whole is of quite general relevance and of some assistance, as at the outset, the Lord President sets out a very brief summary of how the system should work in terms of the law and policy framework in relation to housing land supply. I mean, particularly paragraphs 4 to 9 of the judgment, he sets out the theory behind the strategic development plan, local development plan, and how that interacts with the provisions in SPP. So that's worth a quick read for anyone wanting a crash course on how it should work. One of the issues that obviously been high in people's minds and of some controversy in the Gladman case and over a large number of planning permission applications and reporters' decisions was what the correct approach to the calculation of the 5-year housing land supply was, and the basically 2 competing views as to whether the past completions should be taken into account when looking at the number that should be looked for in the future completions to see whether there was a future supply that was required, to see whether a shortfall in the past should be taken into account, or whether it should just be a more straightforward average yearly amount from the total number divided by the number of years still left in the plan. And again, this issue arose in this case, but the main criticism of the reporter in this case was not that he had gone for one or other of the methodologies, but they had not really addressed the issue and come to a decision. So we see there in the second paragraph here, the court expressing, as it did in Gladman, its own view of a preference for the compound or cumulative approach, taking into account past shortfall, or if it had been oversupply, rather than the annualized average approach. But notwithstanding that indication from the court that it thought that might be the more sensible approach, he said that is essentially a matter of planning judgment. So the reporter could have decided that the annualized approach was better. What he failed to do in this particular case was pick one or the other and didn't explain what he was doing. He also relied on what's referred to there as policy 17, which was in effect saying if there is a shortfall, what the council should do about it. And the court found that by that stage, it's too late to provide a safety valve, and that the LDP must at the outset provide sufficient housing land to meet the strategic development plan requirements. And again, I'll come back to it maybe at the end, but obviously the importance of this judgment is slightly diluted by the fact that in response, no doubt, to the Gladman decision, and perhaps to a lesser extent in relation to this one, the Scottish Government have, at the end of last year, consulted upon briefly and then adopted revisions to SPP in relation to this issue, and also issued Circular 1 of 2020, making clear that their view is that the average or annualized approach to the 5-year effective housing land supply is the proper way of calculating the matter. So it's of perhaps less value, although it is quite clear from the court's view that the compound approach they thought was better, and that the reporter in this case hadn't addressed that. And then if we look also just over the next slide in relation to the generosity allowance, the court, I think, made clear what most people already understood, was that the difference between the housing land supply target and housing land supply requirement is the SPP guidance that the increase of 10 to 20% should be added to the land supply target in order to make sure there's a generous supply of land. And it's the housing land requirement that is the figure that should be used when trying to calculate whether or not there's a shortfall in the 5-year housing land effective supplies of effective housing land. And the point in the middle paragraph here is that there was a suggestion in this case that the reporter was in effect, by looking at the old tenure figures, trying to reinterpret the actual policies in the strategic development plan. And the court was making clear that it's for the court to decide now what the proper interpretation of a policy is, and it's not what was the previous case where councils could perhaps suggest one interpretation of a policy, and if that was reasonable, the court would not interfere. It's now a matter for the court to decide what the one interpretation is, and here the reporter had failed to do that. And his error in relation to generosity allowance was that he had taken into account the completions in the meantime, and then assumed because that number of houses had been completed, there was no need to take into account the generosity allowance that would have applied to those completions when looking forward to see whether there was a shortfall or not. And similarly, over the next slide, very briefly, the point was that some of the allocations were marked down as mixed tenure sites, and there was information before the reporter as to the breakdown between social and private housing, and he didn't properly take those into account, and he concentrated on the all tenure, i.e. the total figure, to see whether there was an adequate supply, and he had to check the breakdown of that, and he failed to do that. And the next slide, he was also criticised because he didn't appear to have taken into account the submissions made by the appellants in relation to the up-to-date information in the 2018 housing land audit and the appellant's consultancy firm's report that argued how that should be taken into account. And it's interesting, at the end of this paragraph 64, that there's a slight rollback on what I had been previously arguing seemed to be a general dislike by the court, in particular the inner house, of any challenge to planning decisions based on reasons alone. But here they reiterate why reasons are important, because the last 3 or 4 lines of this paragraph, the reporter failed to explain how he had dealt with this new information, which was obviously potentially relevant to the exercise he was carrying out. And if he had taken it into account, he should have explained how he'd taken it into account. And if he was not going to take it into account, he should have explained how and why he was doing that. So the mere fact of his failure to provide reasons for that was another reason why the LDP was quashed. And then the final slide on this, it basically summarizes the reasons why the reporter's decision was found to be inadequate. And the court decided that the appropriate thing to do was to quash the housing chapter of the local development plan. There had been a suggestion by the appellants that the whole plan should be quashed, but the court decided in terms of section 138 that the most appropriate thing to do was to just quash the housing chapter. As I say, this would be an even more significant judgment were it not for the fact that the Scottish Government have since then proposed changing the terms of SPP and issued Circular 1 of 2020. But perhaps my understanding is that there's a challenge to that change to SPP, which will also be of relevance, and there may be others on the seminar who can give more details on that, or not as the case may be, but I certainly understand that there is a current challenge to those revisions to SPP, which will be something to look at for in future. The second case I was going to talk about very briefly, and this is getting smaller, down from about 5,500 houses to just a decision in relation to, well, 9 houses in the end. It had previously been an application for 11 houses. So the individual policies under consideration in this case aren't so interesting or important, but the general principle and point to take from this case of Ogilvy Homes against the Scottish ministers is the court reasserting the importance of taking into account previous decisions in relation to the same site on the same issues. As I say, this case was an application for originally 11 houses on a small area, and it was originally refused because of traffic issues. And then at the second attempt, the applicant managed to satisfy the council in relation to the traffic issues. But again, it was refused by a reporter because of its potential impact on bats and trees in the vicinity. And that then led to the applicant making a third application. And the third application was refused in relation to aspects of design and the layout of the housing development that had appeared in the previous decisions to be acceptable to the decision makers. And so if you look at the slide where, again, the Lord President was the author of the judgment, and the first two parts of the reasons why the decision was quashed aren't all that important there in relation to the interpretation of the particular policy, and the fact that the reporter didn't seem to understand that part only of the site was covered by one particular policy in relation to community facilities. But the third point was this lack of consistency between the reporter's decisions. And again, it is the Lord President, slightly surprisingly, again, finding that the reasons given by the reporter were insufficient, and that was a ground on which he would quash the decision. And it emphasizes that if a subsequent reporter is considering the same site and the same issues and coming to a different decision on the planning merits, that is, of course, allowed, but the reporter has to be very clear and careful to acknowledge not just the fact that the previous decision reached a different conclusion, but to explain why he has reached a different decision. And that's because of the importance of the consistency in decision-making, and the fact that reasons are given in a planning decision, partly to allow the applicant to decide whether it is worth their while trying to make a new application by overcoming the particular reasons for refusal in the first place. And it's somewhat unfair to then go back to another reason that didn't seem to be causing a problem any longer. So that's set out in some detail over the course of the next 3 slides, quoting from the judgment itself. And then moving swiftly on to an even smaller housing development, case of McIntyre against the Scottish ministers is actually a case involving the interpretation of the use classes order and whether or not the house owner required to seek planning permission in the first place to turn the house into a residential unit for up to 4 children who were looked after by non-resident carers. And it was a charity. Go on to the next slide, James. It was a charity and based on the ownership by the Church of Scotland, and the proposal was to have 4 cared for children living in the house with 3 full-time carers, 2 of whom stayed overnight. And go on to look at what the use classes order says in relation to class 8 and class 9. Obviously, at the time, the house was merely that, a house, and the question was whether this new proposed use fell within use class 9 houses or whether it fell within use class 8, which the relevant part of which was the relevant residential institution use for the provision of residential accommodation and care to people in need of care other than a use within class 9. And in terms of class 9, it was whether it was being used as a house other than a flat, whether or not as a sole or main residence by 2 not more than 5 residents living together, including a household where care is provided for residents. And the main points to be taken from this case are that this is not a question of planning judgment when one is examining whether or not planning permission requires to be applied for, or whether the proposed use falls within the use class orders. It's a matter of law and a matter for the court to interpret the words of the statutory instrument, and not any question of judgment on behalf of the reporter. And the court was very clear on that. That's paragraph 27 of the judgment. And this was notwithstanding the fact that Scottish Government guidance that accompanied the use classes order might have suggested that a different result would be reached. And that's set out in the next slide. where the court acknowledged that the guidance that accompanied the use class order tended to suggest something else, but that it went beyond the actual wording in the use class order. And I think the court is correctly suspicious that the reason for that is that the wording in the English equivalent is slightly different, and the guidance was probably also based on the English equivalent. And the question that arises, I mean, the indication there in the circular was that in the case of small residential care homes or nursing homes, staff and residents will probably not live as a single household. That use will therefore fall into the residential institutions class, regardless of the size of the home, which would tend to suggest that in the factual situation we had here, that it would be a use class 8 rather than 9. But the court said that the guidance didn't reflect what was actually said in use class 9. And on their reading of the wording of use class 9, that the 4 children would be using the house as a house, and there was no need to look further into the question of whether they were living as a single household, because that was more relevant to the question in England rather than in Scotland. And I don't think the actual detail needs to go any further in the time available looking at it now, but the main point to take is that it's a question of law, what the use class order says, and for the court to determine. And finally, the last 2 cases, very quickly, 2 out-of-house decisions. The first one is, again, a follow-up to a case the previous year, and it just emphasizes that there are practical consequences, and there is still, I think, a danger that people misunderstand the importance or the consequences of an application made under Section 42 of the Act, as people think it's to vary the conditions attached to a planning permission, but actually it results in a separate planning permission with different conditions. So in the case of Canton Central Developments, they applied for a Section 42 application in relation to a outline permission, and the only change in the condition was to extend the time within which to lodge MSC applications. And then they tried to rely on the original permission when saying that the fee limit had been reached and they didn't have to pay any more. But the court found, Lord Tower found, that because it was a separate permission and the fee limit started again because it was a new permission which was being implemented. And finally, the other Granton Central Developments, City of Edinburgh Council, same name, and to make matters worse, there's another Granton Central Development City of Edinburgh Council case that was issued on the same day, and that was not really a planning case, it's mainly a commercial court case on contractual interpretation. And it only briefly mentioned the Section 75 element of that, but I think Section 75 agreements are something that may well be subject to new cases. I'm aware there's a number of appeals against Section 75 agreements on developer contributions and how the reporters or the court would decide they should be approached. So again, that's something that may be happening in the future. But that's just one to have a quick look at if you've the time and the inclination. And fortunately for you, my time and inclination has expired, so I'll hand over to Fergus.
Alistair, just before you do that, first of all, thank you very much. And just pick up 3 points on that you trailed in part, or perhaps the first you didn't. First, that the Lord President's continuing interest in planning cases is evident from the number of opinions he's giving on the subject. The second was that a further case is due, I think, before the courts in June, potentially July, on housing land supply rising from a challenge to a decision in West Dunbartonshire. And that may, it's case specific, but it will give an indication of he approached the court post-Gladman. And lastly, as Alistair indicated, and by way of introduction to Fergus and I were involved in a very recent challenge to the new changes to SPP on housing, land supply and other matters. And we're expecting an opinion in that matter, certainly within the month. So that one hopefully will be worth watching for whether we win or lose. So with that, drawing that to Alistair's to the conclusion, that's introducing Fergus Cahoon, who some of you may not have met, but he's a newish member of Terra Firma, been involved in a number of planning cases, and he's going to talk to us this afternoon on practical procedural points for legal planning appeals. So over to you, Fergus. Thank you.
Yes, thanks, James. I should say, by way of a brief introduction, I gave this section of the seminar the title "A Pair of Practical Procedural Points for Planning Appeals," because it amused me. In point of fact, the majority of what I'm going to be talking about is relates to judicial reviews, but that didn't scan properly, hence the etc. in brackets. If you could move to the next slide, James. So naturally, this topic covers what might more naturally be categorized as administrative law rather than planning as such, but it does, it's equally true that these are points which require to be addressed regularly in planning appeals and planning cases. So an awareness of them, discussion of them can only be of some benefit, I think. So if I'll start with time limits on the next slide. You'll see set out on screen the terms of Section 27A(1) of the Court of Session Act 1988, which affects all planning judicial reviews and indeed all judicial reviews generally, and has come up twice over the past year in planning cases in an interesting fashion in any case. I won't bother to read it out to you, but there it is. I'll start by recounting the facts of a case in which Mr. Findlay and I are presently involved, namely the challenge to the Scottish planning policy, which James just referred to, and which those watching may or may not be familiar with. So the situation is that the Scottish Government lost a challenge to a determination made by one of their reporters, and decided, in view of the somewhat doubtful chances of success on appeal, to simply change the policy under which the determination was successfully appealed. And that decision, of course, wouldn't affect the particular determination which the court had been concerned with, but it would prevent other decisions going the same way in the future, which the Scottish Government, for policy reasons, wanted to avoid. In furtherance of that aim, the Scottish Government proposed a change to the rules, which would prevent the court's ruling on appeal affecting future cases, and in other words, restoring the status quo ante. Having done so, they set up a consultation to canvass public views on that change. That consultation was, in a number of ways, allegedly objectionable. It presented the proposed change as technical and minor, on the justification, effectively, that the proper comparator was the status quo which existed prior to the court's appeal decision. On the same logic, pre-screening assessments were provided which suggested that the change proposed to the Scottish planning policy would have no or very little effect on the outcome of decisions. And arguably, those features of the consultation would tend to suggest to consultees that a response to the consultation was something they didn't really need to worry about. Further, a significant piece of evidence in the ultimate determination of the Scottish ministers to implement the change was not consulted upon. Now, without wishing or needing to go into further detail about the merits of the objections which were made to the consultation process, two important points need to be made. First, at a relatively early stage in the consultation process, the parties who ultimately sought to challenge the policy change of the Scottish ministers made representations by way of a letter directly to the Scottish ministers regarding the purported inadequacy of the process. And second, those representations were rejected. And after the consultation process completed, the Scottish ministers followed through on the proposal by changing the Scottish planning policy and by issuing Planning Advice Note 1 of 2020. Thus was the unfortunate, from the Scottish minister's perspective, result of the court's original decision on appeal overturned. And if we could move to the next slide. So, when coming to challenge that change of policy, a significant focus was inevitably going to be placed on the consultation process itself, which leads us to the time limit point. The 3 month time limit placed on the bringing of judicial reviews in terms of Section 37A began at some point. But when did the clock actually begin to tick? So the Act provides that an application to the supervisory jurisdiction needs to be made before the end of a period of 3 months, beginning with the date on which the grounds giving rise to the application first arose. And it was objected that, insofar as the challenge was directed to the consultation, the 3-month period began when the petitioners became aware of problems with the process. In other words, when they were able to object. And the date pointed to was the date on which representations were made to the Scottish Government, i.e. during the consultation itself. The petition had been lodged within 3 months of the change of policy being implemented, but it was a good deal more than 3 months after they had initially identified problems with the process and made those representations. Unfortunately, in ex tempore judgment, the Lord Ordinary agreed with the petitioner's submissions, which just very briefly were that whilst the consultation process itself was heavily criticised, the challenge was against its fruits rather than against the consultation itself, and no objections being made to the decision to commence or conclude it. Second, that the correct date for measuring the time limit was the date on which the outcome of the consultation became known, i.e. at the point that the changes in policy were made by the ministers, because prior to that there was no action which affected the petitioners and against which they could seek review. And third, and most importantly for what I'm going to talk about later, in any case, a challenge to the ongoing consultation would have been premature because there was nothing inevitable about the outcome. It was possible for the ministers to have taken action as a result of the petitioner's representations, although in reality they didn't. So there was no need for a judicial review. The review, therefore, was in time. And if we move to the next slide, a slightly different approach may be seen when analysing a second recent planning case in which time limits were in issue, and that's Energy Contour UK Limited against the Advocate General, which I'm pleased to say you can go and read. The decision on that was reported at 2020 CSIH 37. This was a judicial review concerning the development of wind farms near the MOD's Eskdale-Muir seismic array. And very briefly, wind farms create vibrations when operating, which transfers the ground, forming a sort of seismic noise, which naturally has the potential to interfere with a seismic array. Accordingly, the MOD requires to be consulted in respect of any development within 50 kilometres of the station. The MOD has what it calls a noise budget, which it established following a study in 2005, by which it refers to the amount of seismic noise which won't interfere unduly with the operation of the array. And that noise budget is allocated to different wind farms and proposed developments within the consultation area. So, since 2005, a developer would make a calculation of the amount of seismic noise that their wind farm would cause at the array, and that figure could then be added to a spreadsheet maintained by the MOD containing details of all consented and built wind farms in the consultation zone. And then the additional noise caused by the new development could be subtracted from what remained of the noise budget, and thus the MOD could ensure that the budget was not exceeded. And if the budget would be exceeded, then the MOD could object to the grant of planning permission. The challenge in this case was to the way in which the MOD in practice allocated the noise budget. And without needing to go into detail, it was effectively averred that they discriminated against developments of less than 50 megawatts. The petitioners became aware of the MOD's problematic approach to the allocation of the noise budget in early 2018, when they learned that the MOD were likely to object to their own application and exceeding the budget. And they responded initially by taking the matter up with the Scottish Government. And there followed a series of meetings over the course of about a year, in which the petitioners and the Scottish Government attempted to persuade the MOD that their approach was flawed and that it should be changed retrospectively to allow the petitioner's application to succeed. On the 29th of April 2019, the MOT accepted that their approach was flawed, but declined to apply the new approach to the proposed developments allocated noise budget under the old approach, which meant that the petitioner's development would still exceed the budget and be objected to by the MOD. Relatively insubstantial negotiations continued for about a year after that, or about 9 months after that, and the petition was lodged ultimately at the end of December 2019. Now, as you can immediately see, in the next slide, please, you can choose at least 3 potential dates for the beginning of the 3-month period, including arguably the date in 2005 when the MOD's policy was first formed. There's also the date in 2018 when the petitioners learned of the policy. But of course, whilst they became aware of the policy in or around April 2018, for at least a year thereafter, potentially fruitful negotiations went on between the MOD and various interested parties. And those negotiations could have produced a satisfactory result, which brings us to April 2019, our final date. Now, ultimately, the review was going to be out of time, whatever date was chosen. And the Lord Ordinary held that it would be equitable to extend the time period instead, on the basis that the issue was important, which merited determination, the principle of good administration didn't speak against granting a planning permission, and there was no identifiable prejudice to the MOD. Next slide, please. So what can be drawn from these 2 cases? Without wishing to get bogged down in detailed analysis of an extemporary decision, or indeed of the energy contour case, it's worth observing that in both instances, the court effectively took a pragmatic approach to the issue of time limits. Section 27 doesn't create a new sort of prescription with well-defined start and end points. And the policy balance to be struck by the court is, on the one hand, to ensure that judicial reviews are brought promptly and without undue delay, and on the other hand, to recognise that judicial review is a remedy of last resort and that alternatives should be sought if possible. In that context, the submissions in the SPP challenge, that challenging an ongoing consultation would be premature, have particular moments, I suggest. Because if the problem could have been solved by pointing out the deficiency to the ministers and having them agree to remedy it, there would have been no need for a JR. I'm going to ignore for the purposes of this discussion that the Lord Ordinary took his decision on a number of bases, not just that. As such, to point to the date on which representations were made as the day on which the clock should begin to tick would not really be in the proper spirit of the Section 27A scheme. In energy contour, we have an altogether different approach being taken to the same problem, probably because on any analysis, the challenge was out of time. Nevertheless, whilst it's not entirely clear, it would appear that Lord Tyre held on balance that the 3-month period began in 2018, in April, when the petitioners first became aware of the MOD's policy. Thereafter, and this is where he differs from the approach in the SPP case, he treats the delay in raising the JR whilst negotiations were ongoing with the MOD as being relevant to the question of whether or not it would be equitable to extend the 3-month period, but not to the question of when the 3-month period itself begins. So, can anything be gleaned from those 2 cases beyond the observation that there remains a certain fuzziness about the 3-month period? Possibly. And last year saw actually quite a number of published decisions on time limits and permission hearings in non-planning related areas, all of which play into the fundamental point that the court appears to wish to take a pragmatic approach to this problem where it arises. Now, that's not to say that the court will try to find reasons to allow the challenges to proceed, or it won't take the 3-month period seriously. But where there are legitimate extenuating circumstances, it would appear, be taken into account. And the balancing act, which I described earlier, is recognised by Lord Tyre, who quotes from the Court of Appeal in the Queen on the application of Burkitt, which is on the next slide. Judicial review is in principle a remedy of last resort. Where an applicant sees a reasonable way of resolving the issue without litigation, the court will lean against penalising him for the passage of time, and will, where appropriate, enlarge time if the alternative expedient fails. Very briefly, for those interested in further reading, I would direct you to the decision of the Lord Ordinary in Odibajo last year. It's worth noting that a subsequent attempt to use Odibajo as a test case to get an opinion from the Inner House on the issue of identifying a terminus aequo for the purposes of Section 27A1 was dismissed as incompetent. So this lack of clarity looks set to continue for a little bit longer. Next slide, please. That brings me on to my second and hopefully much briefer practical procedural point, the subject of protective expenses orders, which does actually apply to appeals. We had a decision last year reported recently on PEOs at common law, which deserves some brief comment, which is Keating against the Advocate General. Those watching may have a passing familiarity with this case from the news. Mr. Keating is a political campaigner and a supporter of the cause of an independent Scottish state. His action, brought actually as an ordinary action for declarator, sought to establish the power of the Scottish Parliament to legislate the holding of a referendum on Scottish independence without needing an order made under Section 30 of the 1998 Act. Next slide, please. It goes without saying that Mr. Keating's action did not fall under Chapter 58 of the Rules of Court. That applies effectively to environmental actions, proceedings subject to the Aarhus Convention, and proceedings that have an breach of environmental law, etc. If your action falls within that definition, a PEO will be granted if, objectively, it would be prohibitively expensive for the applicants to continue. Mr. Keating's instead applied for a PEO under the common law, the competence of which has been confirmed multiple times. But the test to be applied is rather more stringent. Lady Poole referred to the Corner House criteria, which were established in 2005 by the English Court of Appeal and approved for the Inner House in 2013 at Newton Mearns. Next slide, please. And here they are. Numbers 1 and 2 particularly are simply issues which you don't need to address if you have an environmental case running under Section 58A, Chapter 58A of the Rules of Court. Mr. Keating's, it should be observed, failed in his application for PEO because he didn't meet all of these. Lady Poole found that the second, third, and fifth criteria had not been met. And a significant consideration in coming to that conclusion was that Mr. Keating's had run a quite successful crowdfunding campaign, and despite his own low resources, appeared to have the ability to raise further funds by the same mechanism without real difficulty. And the briefest of glances at these will confirm that this is a good deal more stringent than Chapter 58A. When it comes to PEOs, if your case has an environmental bent, then you are effectively, and perhaps justifiably from a public policy point of view, absolved of the need to demonstrate that your case is of general public importance. Next slide, please. All of which brings us on to the question, is the test likely to be met in any individual case, which those watching might be involved with? If the case can legitimately be described as environmental, then the answer is almost certainly yes. And yes. Otherwise, I'm afraid it would appear probably not. And that, at that point, I'm going to hand over to James.
Thank you, Fergus. Thank you very much. The two important procedural matters to bear in mind if you're facing or bringing a challenge for judicial review, both time limits and protective expenses. I'm going to finish this afternoon's talk by dealing with two Supreme Court cases, concentrating on one, And if I
James, I think you've muted yourself.
Yeah. The one I was going to talk about is the Heathrow expansion case. This hit the news earlier this week for quite unusual reasons. It's a practice in many courts, including in Scotland now, to release draft opinions or judgments embargoed from public release. But one of the environmental lawyers in this Friends of the Earth case leaked it in advance, and as a result has been fined £5,000, and is the first person ever to be found to be in contempt of the Supreme Court. And it's perhaps just a warning to those who get embargoed judgments that they are to be taken seriously. But it's also an indication that it's quite an important case. The Friends of the Earth and Plan B Earth brought a challenge to the decision to effectively give the green light to a third runway at Heathrow Airport. The challenge started off in the High Court, Divisional Court, where it was rejected. And there were a large number of grounds involved in the challenge at that case, as there tend to be in environmental challenges. It then went to the Court of Appeal, who rejected every ground of challenge save one, which was that the government had failed to take into account that it had signed up to the Paris Climate Accord. It signed that in April 2016, and it was ratified in November 2016. And the Court of Appeal considered that their failure to acknowledge it and or treat it as policy gave rise to an error in law. The matter then went to the Supreme Court, where the joint opinion of Lords Hodge and Sales represented the opinion of the court. The challenge was to a decision in 2018 to issue a national policy statement on airports, which, as I said, effectively gave the green light to the third runway. And it was set against the particularly or even peculiar English background that development consent orders are the way that large proposals are dealt with in England. They haven't featured north of the border yet. And they're governed by the Planning Act 2008. And one of the matters that states is that the decision makers, when issuing documents such as a national policy statement, the NPS, have to have regard to government policy. And that gave rise to the first issue in the case. What was government policy? And whilst one might think that it's somewhat esoteric, the Supreme Court case, based as it is on whether one should have regard to the Paris Climate Accord or not, and that it's unlikely to be of particular relevance to domestic law in Scotland, I would suggest to you that there are three, if not four, reasons why this case is of some considerable importance. The first is that it looks to see what government policy is, and whilst it's a matter of interpretation of the Act in the specific case, it's of some importance to see what the Supreme Court said about it. The Court of Appeal was of view that policy was, as I've put in the bottom of this box here, just an ordinary English word to be applied in the ordinary sense in any given context. The Supreme Court disagreed. And of some importance, it said there should be clear limits to what statements count as government policy, and they should be readily identifiable as such. And they made the perhaps obvious point that government policy is usually put in a formal written statement of established policy, such as the SPP. But government policy isn't limited to that. It can derive from a number of situations, including in certain occasions, statements, usually written statements, before Parliament. The court was prepared to accept that policy could be promulgated by government beyond written statements, but suggested they should be clear, unambiguous, and devoid of relevant qualification, which are the legal test for legitimate expectation. They made it clear that it doesn't include inchoate or developing policy. And on particular relevance to this case, it didn't include a ratified international treaty, not implemented in domestic law, or mere policy commitments. So sometimes when you are looking to challenge a case or even defend a case, there may be the outer limits of policy. And for instance, in some wind farm cases, some applicants are seeking to put weight on the preliminary stages of MPF4, but that is probably best described as inchoate policy, and so wouldn't be policy for these purposes. So that's the first point, that it could be relevant in domestic jurisdiction. The second is to confirm a point that I'll illustrate by my second case, but has been developing in importance, although it's of some age itself, that the categories of material considerations, which is after all at the heart of many planning decisions, both legal and practical, there's a specific legal classification. There are those considerations which are identified by statute as being material. And an example of that is the one I've just referred to, that the Planning Act 2008 in England said that you had to take into account government policy. There are those considerations that a statute may say are not material. And there are those considerations that a decision maker can have regard to if he or she wishes. And it's that third category which gives rise to most legal contention. And that is a category where the premise is that the decision maker can decide to have regard to them or can decide to ignore them, and doesn't need to give reasons for doing so. There is a subcategory of the last group, isn't that some matters will be so obviously material that they have to be taken into account. And that's what arose in the Friends of the Earth case. It was argued that the Paris Accord was so obvious, it was a matter that had to be dealt with. The court confirmed that whether a matter or not is so obviously material that it needs to be taken into account is a matter of Wednesbury irrationality. That's the test. Quite often it will be obvious what needs to be taken into account, and it's not just statutory considerations or policy. It could be other things as well. The actual question in Friends of the Earth was whether the Secretary of State had acted irrationally and omitted to take the Paris Agreement into account further than he had done, or give it greater weight. And the court affirmed again that these are matters of rationality or Wednesbury unreasonableness, and that what weight you give to a policy is for the decision maker. And as Lord Hoffman, in one of the many Tesco cases, determined some time ago, it's perfectly rational for a decision maker to conclude that a consideration is relevant but give it no weight. So it's a restriction on the grounds of challenge. Just because you think something should have been material and hasn't been taken into account doesn't give you a right of challenge. It has to be so obviously material that you have a ground of challenge. The third issue, or the third way that the Friends of the Earth sought to bring the Paris Accord in, was via a strategic environmental assessment challenge. And the Supreme Court endorsed a number of previous cases, but really for the first and or clearest and for the potentially the first time, said that the adequacy of an environmental assessment, akin to the adequacy of an environmental impact assessment, is to be approached on the basis of, again, of Wednesbury unreasonableness. So that it's a high hurdle if you wish to challenge a SEA or an EIA, and on the basis of information that could have been included, but it doesn't necessarily need to be included, or decisions as to whether there was sufficient information, for instance, to reach a particular conclusion. They also made it clear, confirming some English Court of Appeal authority, that the SEA and indeed EIAs can be cured, any defects in them can be cured, provided that curing takes place before any final decision upon which the environmental assessment, strategic or otherwise, takes into account. But perhaps the most important reason that this is important is that the court stressed yet again that no unduly legalistic approach should be taken to challenges, and highlighted a passage from Advocate General in a European case that judicial review of environmental cases, although one might not think of it from looking at the reports, is limited, and only a limited judicial review of action must be exercised, since otherwise that authority's freedom of action would be definitively paralysed. And that chimes with many of the comments of the Lord President in the RSPB case some 2 or 3 years ago, as to the restrictive approach the court will take, both in terms of challenges to expert judgments, technical judgments, and over legalistic challenge. The fourth ground was fact specific and won't have any import into the domestic jurisdiction. But the fourth point I would suggest is important from this case is it shows you how difficult it is for environmental challenges to proceed. At least I hope that's the case, as Alistair and I are co-defending an environmental challenge involving a spaceport in Caithness in a few weeks' time. We shall see how we get on. My second and last case, and I note we have no questions, so we'll finish shortly, and apologies for slightly overrunning, although I will ask the panel if they've got any comments, is one that I had referred to in last year's lecture. It's the Samuel Smiths and Yorkshire Brewery. These horses are now getting some exercise, the pub's being open again. This was an illustration of the second issue that I was talking about with respect to the Friends of the Earth. When are material considerations, when do material considerations fall within that subcategory of the third group, that they're so obviously material that they need to be taken into account? Now, the background was planning law, particularly English consideration of Greenbelt, because their approach to Greenbelt policy is different from Scotland, worded. But the case is important for two reasons. Firstly, the approach to interpretation of planning policy with the law is identical in Scotland and England, and it reaffirms the Tesco and Dundee approach that Alistair alluded to earlier. And secondly, as to material considerations, there's a disagreement between the first instance judge and the Court of Appeal about whether visual impact in Greenbelt was a obviously material consideration. The Divisional Court saying no, the Court of Appeal saying yes. Once again, the Supreme Court came down against the Court of Appeal in favour of the Divisional Court, and in this case felt that the relatively limited visual impact was not so obviously a material factor that it needed to be alluded to. Greenbelts are primarily about openness, not about visual intrusion. And they stressed that this, whether it was so obviously material, was primarily a matter of planning judgment, not law. Again, subject to the Wednesbury unreasonableness criteria. Frankly, you have to show that it's perverse that a factor has not been taken into account. So those are two, particularly the latter, although ostensibly just dealing with the Paris Climate Accord, in my view, an important Supreme Court cases. So that's all I had to say. there are no questions and answers, but I'll just see if either of my co-panelists wish to raise a hand to say anything, but they're both keeping their arms strictly by their side or on the desk in front of them. So we'll bring the series and this particular lecture to an end. I've put up on the screen the contact details, and I should thank you for your attendance. Hope that some stage soon we may be able to see more of you in person. We have been in the last year, and to remind you that if you have any subjects that you would be interested in having a talk in the autumn from Terra Firma, to let Emma know. So thank you very much indeed, and good afternoon.